Hey everybody, I'm JD Hoovener, your host of the Bold Today Show, where you, the inventor or entrepreneur, get your daily inspiration so that you can go make the world a better place. We're in step 12 of our series on how to get your patent granted, how to get your invention all the way to that point where you've got that patent. While we're talking about this prosecution phase, and patent prosecution means you've already filed your application, you likely have already gotten an office action or two, and maybe even gone through a petition or appeal, as we talked about yesterday. There are actually more types of applications that you can file while your application is pending. Two main types called divisionals or continuation applications. Divisional applications are those that stem from a core non-provisional filing, and they usually happen as a result of what's called a restriction office action, where an examiner says, time out, you have got more than one invention here, and I'm only going to allow part of your claim set to go through as one invention. This other claims, 1 through 4, are actually drawn to a totally separate invention, and it's going to burden our patent office by trying to include all of these in one invention. You've actually got 2 inventions here, Mr. or Mrs. Inventor. What are you going to do now? And so what they do is they make you pick 1 through 4 or 5 through 20. And let's say, for example, we decide to pick 5 through 20. You file 1 through 4 on a separate divisional patent application. And what's great here is that it gives you gives the inventor a really cool opportunity to then say, use the same specification that was filed originally, and then expand on those 4 claims, and likely add 16 more. You get 20 claims for free. They're all included within the application cost. And so you can get more detailed and nuanced about those 4 claims, expanding the rights and creating what's called a patent portfolio. The second type is called a continuation application, and this happens almost all the time because inventors invent and they don't stop, right? You file your patent application and you keep working on that invention, keep optimizing and improving, and you found a way to make it even more efficient. You found a way to make it stronger. A different material that, if added just right and positioned in the right way, will make it really work. This is when you want to file a continuation application. Midway during prosecution, you may at any time file an additional claim set and use that under a totally separate parallel patent application that will get separately examined and get separately processed. One of the main tests, though, is you've got to make sure that those improvements are actually patentable above and beyond your original filing. The examiner is going to look at and use your own patent application, your non-provisional filing claims on the core invention, to make sure that it's novel and non-obvious above and beyond what the base filing was. So, lots of complication there. We're willing to help you understand every single part of that. The key to know is that we want to help you build not just one patent, but build a portfolio, because you have invented something that likely is going to be several patents deep. That'll give you the broadest protection in the marketplace, and when it comes time to enforcing your patent rights, the best chance in getting either a license or a clear settlement in your favor. I'm your host, JD Hoovener of the Bold Today Show. Go big, go bold.